Alors bonjour à tous. Donc nous allons essayer avec l'aide du service de la DABM de mettre en place un nouveau procédé pour la captation des cours, peut-être plus lisible pour vous et qui vous permettra d'avoir en visuel normalement, alors peut-être pas du premier coup, mais on va essayer plusieurs fois, tant la vidéo que le PowerPoint qui défile. Et non pas une vidéo qui fixe le PowerPoint. Donc c'est pour ça qu'on fait quelques petits tests. Et si jamais c'est pas OK du premier coup, la fois prochaine peut-être, ou qui sait la fois d'après, mais on va essayer de s'améliorer. Alors, avant de reprendre ce cours, donc juste quelques mots pour vous dire que vous allez sans doute être un petit peu perdu dans le PowerPoint puisque je l'ai complètement remanié. Donc, non pas dans le fond, mais dans les slides. C'est-à-dire que j'ai réorganisé complètement cette partie du cours. Vous avez tout dans les slides, mais certainement pas dans l'ordre que je vous ai donné. Donc, pas de panique, néanmoins, ça sera tout à fait linéaire. Mais voilà, si vous ne retrouvez pas l'ordre des PowerPoint, c'est tout à fait normal parce que j'ai changé les choses entre la semaine dernière et aujourd'hui. Donc ce que je ferai, puisque je n'ai pas eu le temps de le faire ce matin, c'est que je vous posterai un nouveau PowerPoint avec l'ordre des slides tels que je vais le présenter aujourd'hui pour que d'ici à demain, vous ayez tous les éléments. Okay, so last week we began to study the notion of consideration. Consideration is the third element to be made in order to pass a valid contract. The question that arose before the law court was about the nature of consideration. I gave you some example of what could be considered as a valuable consideration with a small example, and I came to the point of the performance of a contractual duty. Is the performance of a contractual duty owed to the promisor a good consideration? As a principle, performance of a contractual duty is not good consideration. Remember, I stopped here the course last week. Since the person is already compelled under the contract to perform in accordance with the promise what has been agreed to, therefore, performance of something that is already considered as a contractual obligation is not good consideration. However, there are two exceptions to this principle. The first exception can be found in the case Hansen and Royden. Hansen and Royden, a pretty old one, 1867, where it was held that when the promisee had done more than he was compelled to under the contract, therefore, what he has been promised is supported by valuable consideration. So where the promisee had done more than what he was obliged to under the contract, therefore he provided good consideration for any prospective promise made to him. In this particular case, a seaman was employed under a working contract. A seaman agreed in the course of his working contract, agreed to perform the job of a second mate. A second mate is the equivalent of a captain's deputy on a boat. So that seaman agreed to perform the job of a second mate, that is to say a captain's deputy, and considering what he has done, he later claimed for extra wages. He said that he was entitled to more money for extra payment because he currently did the job of a captain's deputy and not as a, let's say, simple regular seaman. And Royden argued that although agreed, there was no consideration for extra wages. There was no consideration for extra wages, considering the fact that Hansen was executing his working contract. He was performing his working contract. And therefore, this claim for extra wages was not supported by consideration. He was already compelled under the contract to work for the company. And the court in that case held that by carrying out the function of a second mate, the seaman has done more than what he was compelled to according to his working contract. And as a consequence, his claim for extra wages was supported indeed by consideration. He was tied by a working contract and indeed was under particular working obligation, but he has done more than what he was compelled to under his working contract by carrying out the job of a captain's deputy instead of the one of a regular seaman for what he was hired for. So consideration came from the fact that he has done more than what he was compelled to under the contract, although he was indeed tied by a working contract in this particular case. So that is the first exception to the principle according to which the performance of a contractual duty is not good consideration. If that person, although tied by a contract, has done more than what he or she was compelled to, according to the terms of the contract. The second exception can be found in the case William and Roffey. In this particular case, the court held that before a new promise is made, the circumstances have changed. So in the situation where the circumstances have changed so as to entitle the promisee to refuse to carry out his or her contractual obligation. So there is an original contract, and later on the circumstances change so as to entitle the promisee not to carry out his contractual obligation. And where that person pushed himself or herself to meet the original contractual terms, therefore, what he has done is supported by consideration, is considered, as consideration, as a valid consideration, where the promisee would have been allowed to escape from his or her contractual obligation because of a change of circumstances, and that person did not escape or not entirely escape from his or her contractual obligation, but would have been allowed to. Am I clear? Or I can reformulate maybe. Where one person is tied by a contract, and in the performance of such a contract, the circumstances change, so as to entitle the promisee, the one to whom a promise has been made, not to carry out his or her contractual duty. And nevertheless, he or she does. He or she complies with his or her contractual obligation. Therefore, if a promise has been made, the fact that that person really complies with his contractual obligation is a valuable consideration. I give you the facts of William and Roffey maybe to fix in your mind this principle. In this particular case, a contract has been passed aiming at refurbishing a block of flats. The contract was about the renovation of a block of flats. The work to be done was carpentry work. And because of financial difficulties, the plaintiff William couldn't make it. Indeed, the price paid to him was too low, and the price agreed was too low. Roffey paid him not enough to enable him to complete the contract. And it was very difficult for William to complete the work on time and to refurbish this block of flat because of these financial difficulties. But Rafi, in that case, who was the one who required the work to be done, Rafi, on his side, was tied by a penalty clause regarding the delay of delivery of this flat. On his side, Rafi was tied by some other contracts with other parties, according to which a penalty clause was due. That means that he was compelled to pay a certain amount of money for each day that were spent later than the date that the delivery should have been made. So is the notion of penalty clause clear for you? He was tied by a penalty clause regarding the delay of delivery. So therefore, Rafi proposed to William that he would pay around £500 more per each flat on completion, provided that these flats were renovated on time. So as a consequence, Rafi promised to pay William a little bit more than £500 more than the initial agreed price, provided that William delivered this flat and complete the work, the carpentry work, on time. And William managed to refurbish 8 further flats on time. So William managed to complete on time 8 further flats, although not the entire carpentry work was finished, but 8 more flats were completed on time. Therefore, he was entitled to more than £3,000 of extra money that William refused to pay. That Rafi refused to pay, arguing that there was no consideration for this promise, since he was already tied by the contract, he was already compelled by the contract to refurbish these flats on time. So there was no consideration for this extra payment because he was already compelled by the contract to complete the work on time. So William brought a claim for the amount promised to him, and Rafi argued that there was no consideration for it, and that the second agreement was not a binding agreement. But the court considered in that particular case that consideration had been given by William for the extra payment, as Rafi, the defendant. So the court considered in this particular case that a good consideration was provided for by William for the extra payment that has been promised to him, because the defendant, Rafi in that case, gained a practical benefit with on-time completion. Rafi gained a practical benefit of on-time completion, resulting in the fact that on his side he escaped from the penalty clause. So in that case, the court has to assess whether or not the promise to complete on time for extra payment the promise to complete on time was good consideration for extra payment, and the court considered in this particular case that it was good consideration because the financial consequences have changed, so as to entitle the promisee, William in our situation, to escape from his contractual obligation. And moreover, Rafi in that case took an advantage in this promise. Indeed, by pushing William to complete the work on time, on his side, he will escape from the penalty clause he was tied with some other people. So he clearly gained something in this promise. So the court considered that the escape from the penalty clause was good consideration. The escape of the penalty clause was construed as good consideration, as a valuable consideration. So these are two cases that comes to limit the principle according to which the performance of a contractual duty is not good consideration. In some particular situation, performance of a contractual duty can be construed as a valuable consideration and can support claims for extra payment in exchange of a promise made. Last point on consideration that give rise to a case law and discussion amongst academics is the issue of past consideration. Indeed, as a principle, past consideration is not good consideration. So past consideration is not good consideration. Indeed, an agreement according to which one person promises to another a reward or something in exchange. One person promises to another a reward, an act that the promisee has already done. So if one person promises to one another some reward for something that the promisee has already done, this agreement cannot be considered as a contract. There is no consideration for the promise, as nothing new is given in exchange for that promise. If one person promises to one another a reward for something that the promisee has already done or has already performed, there is no consideration for this promise, and this agreement is not a binding contract. Indeed, if there is nothing new proposed as consideration, or if there is no future thing coming to support this promise, consideration is not a valuable one. Past consideration is not good consideration and cannot support any promise. The leading case is the Eastwood and Kenyon case. Eastwood and Kenyon case, 1840. In that case, Eastwood was the guardian of a young girl. Eastwood was the guardian of a young girl. He was not the father of this young girl, but he raised her. And Eastwood raised a loan in order to give her, that girl, in order to give her a better education. He raised a loan to get some more money in order to finance her studies and to give her a better education, to go in a better school. And after that girl got married, after this young girl got married, the husband promised to Eastwood to pay off the loan. So after that young girl got married, her husband, Kenyon, promised Eastwood that he would pay off the loan. He will reimburse the loan that has been raised for his wife's education. And currently did not pay off the loan, and Eastwood sued him for payment, as he promised to. And the court had to assess whether or not there was good consideration for this promise of paying back the loan. And indeed, the fact that the guardian provided a better education to Kenwood's wife was considered as part of consideration, but consideration was passed. When the promise was made, when the husband promised to pay off the loan, consideration has already been totally performed, executed. Indeed, that girl went to a better school, had a better education, and all the money was paid. So consideration was totally passed. All the elements that were part of consideration has already been performed. So past consideration is not supporting a subsequent promise, where the promise comes after an event that is considered as consideration. Therefore, there is no consideration for this promise. Nothing new is given in return. In identifying whether or not consideration is actual or past, the courts will have a look at the sequence of the facts rather than the terms of the contract. What is important in the court's reasoning is the sequence of the fact. Maybe the timeline of the facts, what happened first and what happened in a second time. The court will have a look on the sequence of the fact rather than the terms of the contract in order to determine whether or not consideration is present or is already past. So keep in mind this principle, past consideration, where consideration has already been totally performed. Past consideration is not good consideration for a promise that is made. However, this principle is moderated. Once again, there are some, not properly speaking exceptions, but there are some moderation that has been highlighted by the courts. Indeed, the theory that has been, for example, used in the case Parhon versus Lo Yulong, the theory of implied assumpsit comes to moderate this principle. So the principle is the fact that past consideration is not good consideration. However, sometimes the theory of implied assumpsit can be argued. The application of this theory can be argued. And where an implied assumpsit can be highlighted, therefore, consideration can be considered as a valuable one, although it has been performed before the promise. So the theory of implied assumpsit can be explained as following. An assumpsit is an undertaking to perform a parole agreement. There is no written contract. There is a parole agreement between two persons. That's an assumpsit. One person undertakes to perform something that she or he has agreed orally. There is no written agreement. That's an assumpsit. An assumpsit, so, is an undertaking to perform a parole agreement. And according to the Parhon versus Lo Yulong case, the court considered that where the act that the promisee has performed, where the act that the promisee has performed has been accomplished at the request of the promiser. So where the act that the promisee has accomplished has been performed at the request of the promiser, and where subsequently the promiser promised to pay for it. So the promisee has done something at the request of the promiser, and later on the promiser said that he will pay for that, he or she will pay for that. In these particular circumstances, the promise may be enforceable. It could be considered as a binding agreement. So in these circumstances, this agreement could be considered as a binding agreement where the following conditions are met. So in these particular circumstances, where the promisee has done an act, has acted, in a way at the request of the promiser, and the promiser subsequently promised to pay for that action or for this good provided. Therefore, this promise could be enforceable where performance have been at the promiser request. First of all, it must be proved that what has been accomplished by the promisee must have been accomplished at the promiser request. He or she asked the other to behave in a specific way. And it must have been clearly understood by the parties that the promisee would be rewarded for that, even though nothing is agreed on specifically. A reward must have been contemplated by both of the parties, even though nothing is promised, strictly speaking. It must be clear in the mind of both of the parties that a reward will be provided for that. The promiser asks the promisee to behave in a specific way, and he makes it clear that the promisee will be rewarded. Nothing is, clearly speaking, promised at that time, but a reward is contemplated. And the last element that can be highlighted in order to explain this theory, where the court considered that at the subsequent promise of payment being made prior to the performance, it would have been an unenforceable promise. Indeed, if we look at the facts, putting the promise first and the consideration in a second place, consideration would have been a good consideration. Indeed, the theory of implied assumpsit cannot come to make a non-valuable consideration becoming a valuable one. It should have been a valuable consideration, whether it would have been provided after the promise. So if the judges look at the sequence of the facts, putting the promise first and consideration as a second step, it would have been a good consideration. It would have been a valuable consideration. So if these three elements are present, an action at the request of the promiser, a clear understanding at the time of the request that a reward will be granted, even though nothing is promised, A subsequent promise then is made. Indeed, I will pay you for that, and a specific amount of money is promised. The fact that what has been accomplished prior to the promise, properly speaking, will not prevent the promisor, will not prevent the promisee to claim for enforcement of the promise that has been made to him, since what is considered as consideration in this case is valuable consideration. It's something of value regarding the criteria settled by case law. Do you have any question on this theory of implied assumsit? I was clear on this point? Yeah? Is the notion of consideration clear for you after this this presentation and what I have presented to you last week? Do some of you have any questions on consideration? Consideration is clearly what distinguishes the common law contract from the civil law contract, since there is no equivalent requirement in the civil law contract. I'm clear on this point? It's okay? Okay. So with this last point on past consideration, I hand this third part on legal condition to pass a valid contract. So we have, first of all, focus on the intention to create contractual relationship. Then I present to you the requirements of an agreement process and the offer and acceptance concepts. And we have gone through the issue of consideration. The last condition in order to pass a valid contract, according to English law, is a sufficient certainty in the terms of the agreement. If the terms of the agreement are not certain, are not precise enough, this agreement cannot be considered as a contract. In order to be binding, in order to be construed as a contract, this agreement must be certain. The terms of the agreement must be certain. So in the PowerPoint at that stage, the one that you have on the Moodle, I presented to you the doctrine of estoppel, but I prefer to end the 4 steps to pass a valid contract before introducing you this particular part of common law contracts. So I directly move to the chapter on certainty of terms. So in the course of negotiation of the agreement, a certain amount of statements can be exchanged, or either orally or in a written way by the parties. Indeed, negotiation may sometimes take days, weeks, or months. A lot of things can be said or done at that time. And not everything that has been written or said in the course of negotiation constitute the term of the contract. Indeed, what have been said, what have been discussed about in the course of dealing, in the course of negotiation, is not forming the terms, the entire terms of the contract. What is important is on which the agreement is passed, and the certainty of term is a fundamental issue in English contract law. The certainty of term is a crucial point. Indeed, if one statement, if something that is said or proposed, if one statement is construed as a term of the contract, therefore, a failure to comply with this term So if one statement is interpreted as being a term of a contract, the failure to comply with this term will be interpreted as a breach of contract. So this is a legal term, a legal word that you will have to keep in mind. So if a statement is considered as a term of contract, of the agreement, a term of the contract, therefore, if one of the parties fails to meet this requirement, then this party is in breach. The breach of contract is something that I will develop later on, but the breach of contract is a failure of performance. And this is dealt through a particular set of regulation and principle. So failure to comply with a term of contract is interpreted as being a breach of contract that gives rise to a specific legal claim. So breach of contract is a particular situation where the contract is not performed according to its term. So it's very important to determine what are the terms of the contract so as to be able to assess whether or not the parties are meeting their contractual obligation. And if one or both of the parties are not meeting the contractual obligation, they are considered as being in breach, and some particular remedies will be offered. So the court has been asked to settle principle so as to assess what the contract is about and what are the terms of the contract. And the main difficulties in this assessment lies in the possibility of ambiguity in terms, or vagueness. The terms are very vague. There can be some opposite interpretation of the term of the contract. So that's one of the possible difficulty that the court has had to deal with. The vagueness of the terms. Terms are not are ambiguous, are not enough precise. And the second difficulty that the courts have had to deal with is the notion of incompleteness. Sometimes the terms are too vague, unprecise. Sometimes the terms are not exposing all the contractual requirements. The terms are incomplete. Something has not been inserted to in the formal agreement as a binding element, as a binding term, and there are some discussion about that. One of the parties intended the other to behave in a specific way, and the other did not behave such a way, and said that he or she was not compelled to, because it was not expressly stated as being a term of the contract. So the issues relating the notion of certainty encompasses these two aspects, either the vagueness of the terms or incompleteness of the terms of the contract. So you remember I've mentioned that agreement is essential in order to make this contract a valuable contract regarding the law. So the agreement on essential terms is necessary. All the terms will be interpreted, but the essential terms of the agreement must be certain. And courts will be allowed, let's say, to fill in the gaps. Indeed, English courts have a very wide power of interpretation and have the possibility to use any statutory framework in order to make this agreement a certain agreement. So the agreement must be passed on essential terms, even though some details can be vague. If the details that do not affect the equilibrium of the contract are not particularly agreed on, that's not a problem, since the essential terms of the agreement are certain. And the courts have a very wide power of interpretation and can interpret the terms so as to make them certain using specific statutes or any statutory frameworks in order to make this agreement a binding one. So several tests do apply here. Several tests do apply. I will develop some later on. But as a general principle of construction of contract, such as held in the Arbuthnot case, the words must be put in their context. So the court will have a wide power of interpretation, will use a wide power of interpretation, but as a principle, keep in mind that the words will be interpreted considering their context. First step, and I quote, if a particular construction leads to an unreasonable result, it is unlikely that the parties intended that result, unless that intention is abundantly clear. So, if a particular interpretation, a particular construction of the terms of the contract leads to an unreasonable result, it is unlikely that the parties intended that unreasonable result, unless it is clear that they really meant that. Although unreasonable, that's what they wanted. And secondly, always quoted from the Tele2 case that I will develop in a few seconds. Secondly, if a detailed semantic and syntactical analysis of words in a commercial contract leads to a conclusion that flouts business common sense, that means that is not consistent with business common sense, usually it's not the way people are doing things in a commercial agreement. It's not the usual way to do it. So if the conclusion of the interpretation flouts business common sense, is not consistent with business common sense, then the analysis must be made to yield to business common sense. The judge, indeed, judges have the power to reinterpret the term of the contract consistently with the business requirement, what is usually done in commercial agreement in this particular commercial area. So the courts have the possibility to construe the contract in a particular way consistent with, let's say, the usual way of doing things in commercial, in this commercial area. this general rule, this two-step approach, first of all, the look on reasonableness of the terms are that terms leading to a reasonable consequence or an unreasonable result, and then the fact that are the terms consistent with what is usually done in business relationship. These principles were relied on in the Tele2 International Card Company and Post Office case. That is a very interesting in this particular issue of interpretation of contract by the court. I will check if I have posted on the Moodle, but if not, I will. In this particular case, an agreement was passed between Tele2 and the Post Office Limited, according to which Tele2 will supply Post Office Limited with phone cards and phone cards services. So there was a time, you were not born maybe, where people who wanted to pass phone call needed to go to a specific box in the street. They are red in England, you may have seen that, and you put the card in, you inserted the card, and then you were able to phone from these boxes. So it seems a bit weird now that everyone has his or her mobile phone, but it used to be that way. You go to phone boxes and you inserted your card, and then that meant that previously you had bought some phone cards. Do you see what I mean, or not at all? Yes. Then this contract was about the supply of phone cards and phone card services to the post office. And in this particular contract, this clause was inserted, according to which if a phone card account expires, indeed this card had a limited time period of validity. You can use this card, for example, 6 months, and you pay, for example, £20 that you can use within 6 months. You can go in any phone boxes and use that card, but after the 6 months, there is no possibility to use it anymore. So this specific clause was inserted, according to which if a phone card account expires without its full face value or the amount credited having been spent, the relevant contractor, that means Tele2, and the Post Office Limited will share the remaining value equally. So if there is money left on the card, therefore they will split 50-50 the money that is remaining. And amongst all, in this particular case, there was a conflict about the interpretation of the words remaining value. What was intended with these words, remaining value? Indeed, Tele2, the phone card services provider, Tele2 said that the remaining value should take into account what each side had gained on the purchase of the phone card and what costs have been incurred in providing services. So for Tele2, the remaining value must take into account the costs that have been incurred in providing services. And that means that the remaining value should take into account the costs that have been incurred by one or the other party to provide the phone services. And on the other side, the post office said that the remaining value is the money left on the card that have not been spent by the customer. And the court, in that case, held that the starting point for the construction of a commercial contract must be the words that the party use. So I quote, the starting point for the construction of a commercial contract must be the words that the party use. Indeed, it is likely that they intended that the words should mean what they appear to say. So the starting point for the construction of a commercial contract must be the words that the party use. It is likely that they intended that the words should mean what they appear to say. And the court considered in that case that the words face value, the face value was meaning the price paid by the person who has bought the card. It's the price that is written down on the face of the card. You pay £20 phone call with this card. By buying this card, you have for £20 of phone call possible. So the value is, the face value is the value written down on the card, and that is paid by the customer. The court considered then that the remaining value must be the part of the face value that has not been spent by the customer using the phone card. So the remaining value for the court must be construed as the remaining of the face value on the phone card. So the court did not follow the interpretation of Tele2 in this particular case. And indeed, the costs were not integrated in the calculation of the remaining value. Indeed, Tele2 has imagined that this remaining value could be interpreted as the value remaining, for sure, with a deduction of the cost that the party has incurred for providing the services. But the court considered the opposite. Indeed, if the words means what they appear to mean, the remaining value is the value that remains regarding the face value, that means the price that the customer has paid to buy this particular card. And the court considered that it does not lack common sense and it does not produce perverse results for either side. Therefore, the remaining value, the one that will be split into 50-50 by the Post and Tele2 Limited, will be the value that remains on the card considering the face value without taking into account any cost incurred by one and the other party. So this particular case helped to settle some guidelines in the way a court will be ready to analyze the term of the contract. The words must be put in their context, and the words are intended to mean what they appear to mean. In the interpretation, so let's stop here with this interpretation, and I will move to some other aspect after the break. So let's take 10 minutes, please.